So, hi everybody. I'm Bryant Walker-Smith, as Dan said, and we get to share the next hour plus in conversation about law writ large. And if that sounds broad, it is. It's really broad. And so please, with your questions, with your comments, take this in the direction that's most useful for you, your background knowledge, and even the areas of research that you might see as potentially relevant. So with that, I just want to offer a little bit of introduction in that I'm going to be speaking principally about law. Necessarily, I'm going to intrude a bit on policy and ethics because these three domains really are related, but they are not the same. And I think so often people say, oh, lawyers, they must know ethics. They must do only ethics. And ethics is actually a distinct domain. Policy happens in part through law, in part despite law, but it's also a somewhat separate domain. And so the upshot of my talk, if there is one, would be that better law is really important for the societal success of automated vehicles, but it's much less important for the commercial success of those vehicles. For years now, going back, I don't know, to 2011, I've had to hear people say, well, the technology is ready. It must be that something else is keeping us from having self-driving cars. And invariably the blame slowly turns to the lawyers. And people say, oh, it must be the law keeping us from having self-driving cars. And we've seen again and again that actually the technologies are not yet ready. And we'll talk about ready means. But so when they are, law is not going to be the impediment that we think it is to deployment. But getting the right law will matter for realizing the societal benefits that automation at least promises. All right. So let's, with that framing, talk through the history that I think is relevant to this discussion, and then some select legal topics: legality, safety, liability, autonomy, and equity and opportunity. And again, I am with one of my eyes monitoring the chat window. With another one of my eyes, I'm monitoring the increasing wind outside. So between that, I will see your questions, I hope, if you have them. As we're going through this, I will do my best to distinguish between what is my analysis of generally accepted law and what are my arguments about how we should think about or how we should formulate that law. And so generally speaking, you'll see my analysis in white text and you'll see my arguments in red text. Just so as you're approaching this domain, I don't inadvertently suggest that what I think is what everybody thinks. Let's now breathe and go back in time to 1897. 1897 was an exciting year. There was a new transport technology that was revolutionizing the United States. It was changing fashion. It was blamed for the liberation of women. And it even got a mayor in Chicago elected. What is that transport technology? Feel free to type it in chat if you think you know it. What 1897 transport technology was talk of the town? Trolleys, good guess. Trolleys were a little bit earlier. I think all law really is railroads, so I'm totally with you on that. So, there were driverless cars, but driverless meant something different. Oh wow, Benny Benny just offered not just an answer, but a citation. Wow, that is the first time I have ever seen a citation in a chat discussion. Yeah, so it was the safety bicycle, actually, not even electric, just the safety bicycle. One of these two men is the mayor. You can guess which. The safety bicycle was what everybody was talking about. It was going to be the transport technology of the 20th century. And if people were talking about cars, well, they were there, they were interesting, but they hadn't yet reached prime time. Now, fast forward just 15 years, and suddenly the streets are dominated not by horses, not by bicycles, but by the internal combustion engine in 15 years. And for what it's worth, in those same 15, 20 years, we had the first flight and the first commercial AM radio broadcast. Technologies change when they do really fast, or they don't until they do. And all the things that we think are coming take really long, and it's the things that we don't even expect that come fast. At the point that we have automated driving in a broad sense, we're going to have so many other technological changes that in some ways I think will even make automated driving seem a bit boring. But a car certainly wasn't boring back in the early 1900s. This is a 1910, I believe, Buick. And the leading magazine of the age, Horseless Age, had something to say about how these vehicles were built. One prominent commentator wrote that if a manufacturer finds that the axles of his machine are breaking, then the next lot of vehicles are provided with axles of a slightly larger diameter, and so on, until they begin to stand up pretty well. The commentator wrote, "It is in no sense mechanical engineering and is fraught with danger and dissatisfaction." In other words, perpetual beta was not an internet concept. It existed in the products of the early 1900s. And indeed, much of the 20th century has been an experiment in putting 2 tons of metal in the hands of inexperienced people and sending them out on roads at speeds faster than anyone had contemplated before. That has been a broad social experiment with very mixed results. Now, at the time, in early 1900s, a lot of people were actually really excited about cars, and particularly the internal combustion engine, because they said, the internal combustion engine has solved our pollution problems. Now we have green cities at last. What were they talking about? What pollution problems existed? Anybody guess? Citation optional in the chat? Yeah, thank you, Ronan. Horses. Average horse deposits about 10 kilos, 25 pounds of manure a day in New York City at the turn of the last century. There were 100,000 horses. You don't need me to do that math for you. That is a lot of manure. Horses also had the habit of dying in the street, whereupon they would lose their value and be left to rot. It was not pleasant at all. And so the internal combustion engine came around. People said, great, we've solved urban pollution. Until, fast forward, it turns out that we hadn't. And so this is another lesson of engineering or policy, or particularly law, that progress is really about taking one set of problems, replacing them with a new set, and just really, really hoping that our new set of problems in aggregate is less than our old set. So, as I mentioned, people were excited about cars, and cars spread quite quickly, but not everywhere. A few communities actively resisted cars and affirmatively passed laws restricting them. This is the village of Nantucket. The village banned cars, but not the whole island. And so the local postmaster every morning would get up and would hitch his car to his horse and would pull his car to the village limits, whereupon he would then drive it for the rest of his shift, come back at night and reverse it until Years later, after World War I, the village finally repealed its ban. And this is a really important lesson because law is not omnipotent. Right? Just because we pass a law doesn't make it so. Law cannot change reality. Law does not trump the laws of mathematics. Law is just another domain with limited reach. And so that brings us to automated driving, and specifically the question of legality. And on that, I'm going to pause for a second, look over to chat where I get to read horse poop horses, and see if there are any questions. All right. So then let's turn to the question of the legality of automated driving. And I'd like to start with a thought experiment here. Imagine that we had time travel. Work with me on this. Imagine that we had time travel. Is that legal or illegal? Is time travel lawful? Illegal, illegal, legal. Oh, I wish I could ask you why. Why? Yeah, it depends on what. What do you think? What's the best argument it's lawful? What's the best argument it's unlawful? Or what does it depend on? Yeah. Well, I don't know, Benny. I'm really going to look to the mathematicians to help me out on that one. So, thank you, Lawrence. So I love the difference in perspective here. Yeah, so there's a temptation, at least when we're talking about automated driving, to say, well, that must be unlawful because there are no laws specifically allowing it. And that is an argument that is generally not accepted in much of the world. That is, conduct is lawful unless it is prohibited. And so the question is not, is there a law specific to automated driving or specific to time travel, but how does this new technology implicate existing background law, right? When nothing is relevant, everything becomes relevant in the law. And that's why we've, for years, been seeing surveys of the law. I did a big one in 2011 on every law that might possibly implicate automated driving. You could imagine the same for time travel, right? We have to ask, what are the relevant laws? And so, generally speaking, we're seeing opportunities for law to be clarified, but not a lot of instances where law clearly conflicts with automated driving, where automated driving is necessarily, inevitably, absolutely illegal. And so a lot of the movement we're seeing legally involves more clarifying existing law rather than whole-scale revising it. So at the international level, we're seeing resolutions that are embodying interpretations of treaties, further development of technical standards. This is at the UN's Global Forum for Road Traffic Safety and the UN's World Forum for Harmonization of Vehicle Regulations, as well as intrastate or supranational work at the EU level. We're seeing some national or even supranational standards and processes for type approval or self-certification being reviewed with an eye toward automated driving. And please, by the way, feel free to ask if you're not already familiar with the difference between type approval, which is the major method of vehicle approval and regulation in the European Union, or self-certification, which is the primary method of these ex ante regulation in the United States.
Brian, and I'm hoping I'm not the only one that's not familiar with those terms.
Oh, thank you so much for asking. All right, so good. I will turn to that in a second then, and explain the difference between type approval or homologation and self-certification. And so then we're also seeing some national or even subnational rules on driving and thinking about how they apply in the context of automated driving. While all of this is happening, there are lots of deployments going on. So law has not yet been an impediment to the kinds of efforts that we've seen so far, testing, limited deployment, generally under supervision of humans. And if anything, law has either embraced automated driving and its ambiguity or embraced it through specific legal change. So I mentioned at the UN level, we're seeing some efforts that generally recognize that international law either is or can be interpreted to be or can be clarified to be consistent with automated driving. I'm going to use for the next few minutes U.S. law as an example. I'm happy to talk about, in particularly, law of the European Union and its member states. I can speak with sort of less confidence about the specific legal regimes in other countries, although I'm certainly familiar with the general approaches. But I'm going to use the U.S. as an example for the points that I think have broader value. All right. So if we survey existing federal law, generally speaking, automated driving seems to be consistent with it. Conventional designs for motor vehicles are consistent with the Federal Motor Vehicle Safety Standards, which don't comprehensively regulate vehicles, but contain particular requirements that the designs must meet. So conventional designs have steering wheels and brakes. At least under one interpretation of federal standards, you need a steering wheel, and these vehicles have it. Federal law doesn't really regulate non-commercial vehicle operations, and so it has very little to say about a human driving their car to work or school. And commercial operations, trucking and the like, are regulated in part at the federal level, and the responsible agency is thinking through the regulations at this point and determining whether they would be wholesale consistent with all forms of automated driving. We are likely to see some forms of clarification or even change. Vehicles on the streets aren't the only kind. Sidewalk robots are not regulated as a motor vehicle. And so by and large, the federal regime for motor vehicles just doesn't apply. Same for anything in the air. So when we think about the federal regime, it gets pretty complicated. And this is where, thank you for asking, Benny, I can just step back and explain type approval versus self-certification. So in the US, our National Highway Traffic Safety Administration, or NHTSA, establishes specific standards, specific, concrete, objective, falsifiable standards to which vehicles must be certified. These standards don't cover every aspect of the vehicle. They don't even cover vehicle performance generally. They cover particular elements. And so a manufacturer, prior to importing or selling a new vehicle, needs to self-certify that its vehicle complies with these specific standards. And NHTSA may later test randomly or opportunistically to see if these self-certifications are correct using very specific testing procedures. And that's the primary method of standards as they apply to new vehicles being sold. In contrast, Europe and some other parts of the world use a process called type approval or homologation. This is where, to sell a vehicle, the regulator or its designee has to actually approve it. It has to say, yeah, we give you permission to sell this particular vehicle. And depending on the particular country and rules, this can either be approval for individual components. Yes, your brakes work. Yes, your lighting system is adequate. Or for the whole vehicle. Yes, this whole vehicle complies with the standards. So under both regimes, take the US and the EU, there are standards developed. But in the US, manufacturers have to self-certify that they comply. And in the European Union, some other entity, often government, needs to determine in advance that the vehicle complies. What we're seeing with automated driving is actually kind of a move to the middle. Where through the exemptions process in the US, regulators are collaborating more closely with developers. And in the EU, there are moves to introduce a little bit more flexibility, or just the nature of over-the-air updates is limiting the kind of comprehensive review that agencies necessarily do. Generally in the US, and this is surprising to a lot of people, you get to sell things without getting approval. And that covers almost everything we use. It's just the really scary things, the really scary and dangerous things like drugs or airplanes or nuclear power plants or haircuts that require approval in advance. Otherwise, generally, a lot of regulation actually happens in this standards approach. So when we apply this to automated driving, in the US, there are actually a lot of ways that a developer today could deploy an automated vehicle consistent with federal law. And we're still talking just about national law at this point. So the developer could design the automated vehicle to comply. Even if the developer believes they don't need a driver, they could still stick a steering wheel in the vehicle. They could stick 2 mirrors on the sides. They could put a big boxer on the wheel, and their vehicle could be certified as compliant. The developer could seek a regulatory reinterpretation of some of these existing requirements. It's what companies tried doing a few years ago under the previous administration. That administration was cautious in how it interpreted law. You might not find that same caution if you were to seek a similar reinterpretation today, for a variety of reasons. Likewise, a developer could seek a regulatory exemption. And in fact, 2 companies, GM and Neuro, have applied for specific exemptions from the federal requirements, and Neuro has received theirs. This is where companies put forth a safety case for why their vehicle will be at least as safe without a steering wheel as with it. The developers could seek, or the agency could itself pursue, a regulatory amendment to change the requirements, not by going through Congress, but by going through the administrative rulemaking process, which takes a while, but has a fair amount of discretion. The developer could turn to Congress and ask Congress to wholesale change the law. This is what a number of developers did a couple of years ago, unsuccessfully. Congress got distracted by all sorts of other things. The lobbyists for this also got a little distracted by other vehicle issues. And by the time that this reached attention again, a lot had changed in the world of automated driving, and there was generally a loss of trust in the technologies, the developers, and even the regulators that I think ultimately doomed that bill, probably for the better. A company could deploy its system for testing and evaluation. Or a company could operate its vehicles without actually selling them. All of these are at least arguably consistent with federal law. And so when I say it's complicated, this is what I mean. There are no fewer than 7 different ways that these vehicles could be deployed consistent with law. Guns. Yeah, we can talk about that. All right, so let's turn now from federal law to existing state law. So state law has relatively little to say about the sale of new vehicles, at least with regards to safety. Dealership models are another. But state law has a lot more to say about operation, that is actually driving vehicles. And so while the sale of all 3 of these concepts would certainly be arguably lawful, operation is a little more ambiguous. In some states now, operation is explicitly lawful. States have passed laws specific to automated driving, or it's arguably lawful. And in fact, in a number of states, governors have acted on the assumption that automated driving is lawful. Otherwise, they likely would not have had the authority to accommodate automated driving. And by and large, states are very willing to accommodate these technologies, whether through new laws, through the interpretation of existing laws, or just through the general fuzziness and softness that is law. And we'll come back to that point. Law is a lot more flexible and ambiguous than I think people often think. And it is not so easily reduced to code. So I want to give an example of that. But before I do that, Benny, you think you have a question?
You hinted it before a little bit in your last sentence, Bryant, but I'm still wondering, law, so it seems to me there's two aspects. One is you have the law existing, and then the question is, does whatever new technology comes along fits within the existing laws? Whereas, of course, the other extreme is that a new technology comes and all the lawmakers get into one room and think about how do we design the new law. And the truth is probably somewhere in between, but I wasn't completely sure in which that sort of these paradigms or what combination these arguments were established that you had on the last two slides.
Yeah, so I'm talking about the legal framework today. And by and large, I'm talking about existing background law, even before it has been adapted for automated driving at the state level. So principles of existing law have been interpreted in many states as consistent with automated driving. Let me give you an example. Arizona is home to a number of very prominent testing activities for automated driving. Arizona actually has the distinction of being the first state to defeat automated driving legislation. This was years ago, shortly after Nevada passed their law. Oh, wow, has it almost been 10 years ago now? And Arizona's never passed a law specific to automated driving. There's been an executive order, but governors generally can't act inconsistent with statutory law. And so everything that's been happening in Arizona, including at least what Waymo claims to be occasional operations without a safety driver on board, have been under the existing background legal framework. Florida took a different approach and enacted laws expressly authorizing automated driving. But the preface to those laws, the foundation was existing law permits this. California has taken probably the most detailed regulatory approach of any state, and indeed among really any jurisdiction in the world. California has probably produced more pages of legally binding text than just about anybody else, and that envisions a more specific system of approval, particularly approval for testing. And a number of companies have complied with that. And there are actually now several that have been approved for driverless testing within the state. So all of this is with existing law, recognizing that existing law now in the last decade has evolved somewhat to address automated driving. One of the big questions, as you point out in legal reform, is do you sweep existing law away and start anew, or do you try to stretch, extend, adapt existing law? And it's much easier to just adapt existing law. And a lot of the experiments in the past of blank slating law have not necessarily gone well, either from a public policy perspective or just from the political perspective. It's hard to do. And so I'm speaking principally about incremental change against the backdrop of existing law. Benny, did that answer your question? I'm seeing a nod. Cool. Thank you. All right, so state law is also complicated, but you know what else is complicated? Federalism, and the relationship between the federal government and the state government. By the way, you can roughly translate this to relationship between the European Union and the member states, with a big caveat and total respect for national sovereignty. But roughly the same tensions apply under proportionality in the EU. In other regions, China is less centralized on some of these questions than is often kind of assumed. But we're seeing more happen centrally in China, as well as Japan. Canada, Australia, you can roughly analogize them as well to the situation. So federalism, it's very common to hear people say, and by the way, it's very common for those people to be lobbyists for automakers, that the federal government regulates the safety of vehicles and states regulate the safety of drivers. But there's this nice, neat, clean line, and everything that's vehicle is the federal government, and everything that's driver is the state. And so the implication is, as the vehicle becomes the driver, states don't have a role. And I want to really push back on that, because this is just a small illustration of regulation, is a more accurate picture of regulation in the US. So on the left, as we're talking about production of new vehicles, the federal government has a primary role, and in some cases an exclusive role, if it chooses to, on vehicle standards. So we've already talked about the Federal Motor Vehicle Safety Standards that the National Highway Traffic Safety Administration implements. NHTSA also has a tremendous amount of soft power, and this does not get enough attention. So NHTSA can investigate for noncompliance and defects. NHTSA can institute regulatory recalls. As we shift from production to modification of existing vehicles, maintenance of those vehicles, operation of those vehicles, state governments take on an increasing role. First of all, state governments do influence vehicle design through products liability law, through after-the-fact determinations of whether particular vehicle systems were reasonably safe in areas that NHTSA has not preempted. That is, NHTSA has not exercised exclusive control. Yeah, and Raphael, you say, is that actually true in terms of states not regulating vehicle safety? And that's why I crossed it out. And so thank you for reiterating that. It's not true. You're going to hear it a lot. And so you give a great example of emission standards in California. California gets to set its own emission standards because it was already doing so in the 70s when Congress enacted a national regime for emissions regulation. And California has received a waiver ever since so that it can continue to set its own standards. And other states have then been allowed to adopt those standards. That's gotten a lot messier in the last few years. Under the Bush administration, there was an effort to revoke California's special status, but President Bush ran out of time. More recently, the current administration has actually revoked California's status. That is subject to all kinds of litigation right now. And it will be a question whether, again, those efforts more or less run out of time and California is able to continue to set a generally higher standard for its market, and by extension, a lot of the country. So it's another great example of, thank you, Benny. Another great example of how complicated this is in regulation. Benny just offered another example of how complicated this gets. What does the term vehicle safety mean? So, traditionally in the United States, vehicle safety or roadworthiness has principally contemplated the protection of occupants of the vehicle. And it's also contemplated protection of belted and unbelted occupants within the vehicle. And by definition and by regulation and by practice, pedestrians and bicyclists and other vulnerable road users are an afterthought and have in some ways not been within the scope of vehicle safety. Europe has taken a much more holistic approach to vehicle safety, and by law, vehicle safety contemplates, albeit imperfectly, the safety of people outside of a vehicle as well. That's why you see in some ways more attention to front bumper design, to lighting design, and some pretty clever technologies. Now, you can broaden this even more and observe that in the US, there are going to be 40,000 people who die on the roads this year, at least as many, and depending on the numbers you use, far more people will die because of pollution caused by motor vehicles. And so even though these are deaths, right? Even though these are deaths or significant health impacts, they're not generally considered within the ambit of motor vehicle safety. This is a real good example of how how we define the problem determines what counts within it. So states, in addition to having these roles in influencing the safety of vehicles as they are designed and sold, do have principal roles in the registration and inspection of vehicles in the states that do that. This includes the roadworthiness of every individual vehicle. The average vehicle age in the US is 11 years now, actually going up from that. And so states have such an important role in all this, and the federal government largely doesn't. The federal government looks as, was it safe at the point that it was designed and sold? And of course, rules of the road, driver licensing, all tend to be within the ambit of states. Note that these are often functions that are more associated with the driver. And so as the driver becomes something else, the question becomes, how do these apply? So let's take, as I'm looking for questions, let's take the specific example of rules of the road. And there's often these conflicts posited, typically by non-lawyers, that, oh gosh, we have these conflicts in our traffic laws, that the laws say, that you shouldn't cross a yellow line. But what if crossing a yellow line is the only way to stop from hitting somebody? And the answer to that is actually that's not law. Law has a implicit hierarchy that's going to sound a whole lot like Asimov at this point, where the paramount command is don't hit people. If you hit somebody, you're probably going to break the law. Yield the right of way. People don't have the right of way. They only have the expectation that they yield it. After that, follow lawful orders. Many states provide that drivers have to obey traffic enforcement. And then after that, follow the general rules of the road, qualified by all the limited and imperfect and discretionary enforcement that we have. And so as we look to the future, it's a potential challenge that we're going to have this combination of premeditation. In other words, developers will have a sense of the conditions under which their vehicles will comply with law or might violate law as written. And that could be combined with more perfect means of enforcement, by which I mean more comprehensive means. It won't depend necessarily on opportunistic checks by law enforcement, but perhaps on more systematic methods of reporting, or at least the searing examination by a court when something bad does happen. And so the solution to this is for developers to show their work. Right, to explain the trade-offs they're making, the judgments they're making, and to default to safety. You're always better off not hitting somebody than hitting somebody. And this comes back to this first rule. And Benny, It's in traffic law frequently spelled out in that motorists have a legal obligation to exercise due care to avoid striking either other road users or pedestrians and bicyclists. And so that is explicit. It's inherent in law in that necessity is often a defense. So depending on the jurisdiction, you would be able to say, well, yes, I crossed this line, but it was necessary in order to prevent a greater injury. And that would be defense in criminal law often and a defense in civil law. We'll talk about the difference between those shortly. And that actually brings us to next legal topic, safety. That is how law approaches the question of safety. And it's broader, by the way, than just the specific standards that we've talked about. So one way that for years I phrased the key safety question was, have the relevant technologies reached a demonstrated level of socially acceptable risk? And you can see that this involves law and engineering and policy, right? Have the relevant technologies, plural, because there's not just one technology, reached a demonstrated level. So not just a level, but something that we can show, something that we can ascertain, something that we can measure of socially acceptable risk. Not perfect safety, but some level of performance that is socially acceptable. And I think this is now kind of the generally accepted way of phrasing this. And so since I'm naturally contrarian, I've since moved on. And the way that I'm tending to ask the safety question now is actually, are the companies behind these technologies worthy of our trust? And so let's talk about how I got there and what law has to do with it. So key question feeds into all this. How safe is safe enough? And there are two ways that we can answer this. One is prospectively, in other words, before deployments, and the other is retrospectively, after deployments. Prospective safety is the hard one. And this is where people say, oh gosh, what are the standards either in engineering or in law? And this, by the way, has always been a question mark, right? Recall our braking axles. If we applied the standards of safety from 1910 to today, we would not have 40,000 deaths. We would have 400,000, if not more. Or we just, wouldn't be driving as we are. So it's very difficult in any technology industry to conclusively set this level of ex-ante safety in a way that is permanent. And so this brings me to a fundamental question in law. It can be answered separately at the federal level and at the state level, in the technical sense and the legal sense, which is who drives automated vehicles. Law, by the way, will make you dizzy. I'm taking these from, does deployment include the testing phase on roads? I tend to blur testing and commercial deployment because I think that we're going to see mixed deployments for a long time that are nominally research but are actually deployment, or are deployment but really are continuing to feed continuous improvement. So when I talk about you use question of I think you're asking about retrospective and prospective. I'm talking in a general term before things are on the road and after they're on the road. So when we're looking at this question of who drives AVs, law hasn't been very helpful in a background sense. I'm taking these quotations from Maryland law, both statutes and court cases, where we learn that drive means to drive. That's very helpful. 1 equals 1. Drive also means to operate. Okay, so drive means to drive or operate. Operate actually means to drive. So drive means to drive or drive. But operating is generally given a broader meaning than driving. So drive is broader than operate, but operate is broader than drive. If you're dizzy yet, that's okay. The moral of the story is actually that drunk drivers mess up everything, including the law. That we've seen these definitions expand as courts have tried to say, well, if somebody threw their keys away as the police officer came up, were they driving? Or somebody was passed out drunk in the driver's seat, were they driving? And we have this legal complication. So when we apply this to automated vehicles, we're actually get a fair number of answers. And we can have, by the way, different answers in different states, different answers under different definitions of different laws at the federal level or the state level. NHTSA very famously confronted this question a few years ago in the context of a request by what was then Google. And so we could say, well, who drives an AV? No one. At least one state's kind of gone in that direction. Humans, at least for testing, a lot of states have wanted to find a human who is still driving. And certainly we've seen that tragically illustrated in the news yesterday about the prosecution of the safety driver in Uber's crash in Arizona. We'll talk about that. Computer could drive an automated vehicle. A computer is not a legal subject. We can talk about robotic personhood, but I will, kind of preemptively roll my eyes now. But some states have gone in that direction, and declaring that the vehicle itself is the driver. And there are some interesting legal repercussions of that I think largely work themselves out. And some states, and again, I have concluded that companies drive automated vehicles. That it's the companies developing and deploying these systems that are their legal drivers. The most prominent example of that is probably the Automated Operation of Vehicles Act. This is a model law, a uniform law, developed by an interstate group. And so it has no legal force, but it is then recommended to states for adoption. And so we've seen Washington introduce this. And after legislatures resume, post COVID, we'll see if this is ultimately adopted or not in large scale. But this act declares the automated driving provider, some entity that raises its hands, makes a promise to the public, and accepts its status as the legal driver to be that driver for the purpose of state motor vehicle laws. And so I bring this up because I think it gets us to an answer on what prospective safety means. Because I argue that prospective safety means reasonable confidence that the automated vehicle developer is worthy of our trust. Reasonable confidence that the automated vehicle developer is worthy of our trust. Because frankly, that's kind of all we're going to have to go on for a lot of these deployments involving very complex systems and necessarily inadequate regulatory resources. And so what does it mean for a developer to be worthy of our trust? I talk about this much more at length in other papers that you can see at newlypossible.org. But for our purposes, the key is sharing its safety philosophy. To say, this is what we're doing, this is why we, the company, think it's reasonably safe, and this is why you can believe us. And so this might sound like the kind of safety case that developers regularly implement in-house, that engineers develop. It involves the added component of sharing this with the public and subjecting it to critique, the same kind of critique that administrative agencies are good at because courts do it to them all the time. And this was actually the basis for the National Highway Traffic Safety Administration's early efforts at voluntary safety self-assessments. Sadly, those have, I think, more recently moved more from candid discussion into marketing. And so we're seeing more mature efforts actually in the request for exemptions that GM and Neuro have submitted and the agency is reviewing. This public manifestation of a safety case to say what we're doing, why we think it's reasonably safe, and critically, why you can trust us. So I want to mention one concrete aspect of this, which is a proposal for how we might facilitate data sharing. Developers are doing massive amounts of simulation, surprisingly significant amount of on-road testing, and discovering any number of edge and corner cases, right? Scenarios, difficult scenarios. And there's been a lot of interest in universalizing those and sharing them and testing against them. And so proposal is that developers share scenarios. A consortium universalizes these data so that they can be easily translated among various systems, right? I realize that this is akin to, and then magic happens. So let's say, and then magic happens. And at this point, developers can test their systems against these scenarios. But, and here's the key, the consortium makes the results public so that a developer can't design for the test. It can't take the hard situations and come up with the solution that fits those, but not the ones they haven't thought of. They have to come up with the solution that they think will work for everything, and only then can they and the rest of the world see if they're right. Yeah, so Benny, you're asking about responsibility, and it's a great transition to liability, which I will talk about imminently. Let me just say, to close out safety, that we tend to talk about safety as a single test. And there's not a single test in current vehicle law. There are self-certification that encompasses a lot of objective, falsifiable tests, which is not necessarily the direction I think we should go. But we talk about driver's tests. There's often a temptation to say, well, automated vehicle should get a driver's test. But this defines safety much too narrowly. Safety is a life cycle commitment to good practices rather than a single test, right? It's a marriage rather than a wedding that starts before development even occurs and continues long after the vehicle has been sold and is out on the road. And so that's why safety necessarily needs to encompass, prospective and retrospective elements. So let's just touch on this retrospective safety along, because it really does bring us, Benny, to liability. This is the easier answer. How do we know if something's safe after the fact? Yeah, that's easy. It needs to be at least as safe as a human would have performed the maneuver. So if a human driver would have done it better, the AV is not safe. And a NHTSA will conclude that, a jury will conclude that. And the vehicle needs to be at least as safe as a comparable AV. So if another vehicle would have done this better, the vehicle is not safe. And that would be a basis under existing law for NHTSA to recall the system today. I push this a little bit further. I adopt kind of the aviation model and say that the AV also needs to be safer than the last one that failed. In other words, y'all don't get to make the same mistake twice. Now, this would be an evolution of law rather than necessarily where it is now, but I think we're seeing evidence that that's actually where law is moving. And that brings us, thank you, Benny, to your question about liability. Punishing people, that's part of it. All right, so first, I want to emphasize that responsibility has a lot of meanings inside and outside of law. Technical responsibility, who does what, is not the same as legal responsibility, who is expected to do what, or who is liable when it's not done. And moral responsibility, right? Law and ethics, not necessarily the same. Even under legal responsibility, there's a difference between criminal liability. This is when government prosecutes someone for the purpose of putting them in jail or prison or fining them, versus civil fines, which are more administrative penalties. You pay the speeding ticket, but if you haven't sped a lot, you don't get a criminal record. And civil liability, this is where people who are harmed sue the people who caused that harm. And within civil liability, we just go all over the place, right? And we can talk about that if you'd like. upshot here is liability is not binary. With few exceptions, you don't get to say, well, the manufacturer was liable, therefore the driver wasn't. Or the driver was liable, therefore the supplier wasn't. Multiple people can be liable, even in a legal sense. Now, I mentioned this rather timely because just recently we learned that Arizona prosecutors would bring charges against the driver of the Uber test vehicle that crashed 2 years ago and killed a pedestrian. And shortly after that, we learned that prosecutors were not, shortly after the crash, we learned that prosecutors were not going to bring criminal charges against Uber. And it is very tempting to see this as equivalent or as a vindication for Uber in some way. It isn't. I would be happy now or in chat to discuss the legal and equitable aspects of these decisions. But if we look at the cause of this crash, it was a dangerous loop that Uber's engineers said in effect, well, the driver's going to be safe, so our system doesn't have to be. And Uber's drivers said, well, the system's going to be safe, so I don't have to be. And it was this divided responsibility that ultimately left no one being responsible and left a woman dead. And so on this topic of criminal liability, as you asked, Benny, who do we get to punish? Well, the key here is culpability, right? Who did what wrong? And if there wasn't something wrong, there wasn't something culpable, at least negligent, but generally reckless or intentional, then there's not likely to be criminal liability. For manufacturers, what this means is don't lie, steal, cheat, or cover up. That tends to be where most criminal prosecutions originate. A few years back, I participated in this ethics session, ethics conference at a major automaker. And despite my best efforts, this automaker, the CEO of the automaker was just obsessed with the trolley problem and presented this as the paramount ethical issue that, oh, we're going to lead as a company by solving the trolley problem. And I said, that's not your ethical issue, right? Your ethical issue are your engineers going to be honest? Is your company going to be candid, or is it going to lie, steal, cheat, or cover up? 4 months after that CEO was arrested and spent a number of months in prison because of allegations about that company's lying, stealing, cheating, and covering up. That's criminal liability. Civil liability. Civil liability is when victims sue the people who allegedly caused their harm. Now, the purpose of civil liability is first to promote safety, to encourage safe behavior, and secondly, to compensate at least some injuries. Civil liability, unlike criminal liability, is not always a moral judgment. Right? Companies can be held liable civilly even if they acted reasonably on some circumstances, because law says that's part of the bargain. That's part of the conditions under which you get to exist, that we've decided it's socially efficient for you, company, to sometimes pay people who are injured because of your products. And so note how I mentioned that prospective safety means reasonable confidence that the AV developer is worthy of our trust. And so from a both criminal and civil perspective, this implicates untrustworthy conduct. So what is untrustworthy? Making hyperbolic claims, misrepresenting evidence, failing to update technologies when they need to be updated, exploiting the litigation process, and forcing confidential settlements. Uber, by the way, did settle with the family of the victim confidentially, so we don't know the terms. But I mention this also because civil liability is tremendously flexible. And over the course of the 19th century railroads and the 20th century cars, courts figured out how to adapt law. Not perfectly, not right away, certainly not blank slating, but passably well. Right? Law is about second best solutions. And particularly tort law, civil liability is about second best solutions because at this point the injury's already occurred. And so we've Despite, predictions that law would be unable to handle civil liability, Uber settled. In a wholly unrelated case involving another developer of the technology, there was a crash in San Francisco between a test vehicle and a motorcyclist. The motorcyclist sued, and I just love the simple way that this complaint was phrased. Defendant breached their duty in that their self-driving vehicle drove in a negligent manner. So right away, law is just jumping to the idea that, yeah, machines can be negligent. And you know what? Companies should be liable because companies act through their human agents, their employees. This is well established in law, even if we can't always agree who an employee is. And I think courts will pretty readily conclude that companies likewise act through their machine agents, their technologies. And so that brings me to the last two very intertwined topics, autonomy and equity. I talk about autonomy in part to encompass data, privacy, security, data protection. Fundamentally, law is concerned with privacy and security and data, but I think largely from the frame of autonomy rather than necessarily those as the goals. And so data law is and should be, I think, much broader than automated driving. A technology-specific approach probably will not serve the field particularly well, but it nonetheless seems to be an issue that arises a lot in the context of automated driving, so I thought I should loop it in. Current approaches, if we look at history of data privacy, nationally and internationally, tend to be empower governments, empower companies, or empower individuals. Often empowering individuals tends to effectively empower companies. Roughly, you could equate these to the Chinese, European, and US approaches at this point. I think another approach might be, rather than focusing on empowering individuals, empowering collectivities. And this is where I think there's a really interesting opportunity for automation. To use collective bargaining algorithms to figure out people's preferences, to figure out who they might be aligned with, and to automatically understand negotiating positions and use that market power to compel companies to change data practices to the extent that there are constituencies that want changes to those practices. And as we talk about company power, we necessarily need to discuss principles of equity, which are much broader and have particularly in transportation really defined so much of the 20th century. This is today. The status quo is so far from perfect. But think about how automation will change, particularly power relationships. So maybe automation will enable perfect compliance with speed limits, not just for automated vehicles, but for other vehicles on the road. That automated vehicles might be able to police other vehicles and say, well, you're speeding, I'm going to report your data. Maybe automated vehicles will create much better dynamics for pedestrians, that they'll be able to confidently step in a crosswalk knowing that the vehicles will stop. A concern has been, well, will pedestrians step everywhere and will traffic be impeded? Many of the same concerns we had, by the way, in the mid-20th century. And so imagine that a company is operating an automated vehicle and someone steps out in front. They will, if they are designing responsibly, probably be able to stop. Right? We don't need to deal with these hyperbolic edge cases that presume omnipotence and omniscience up until the point, only at the point of failure. But so the company will stop. They'll identify the person. Maybe they'll even be able to identify who it is through facial recognition or some other approach. At that point, they might report the person for jaywalking, or they might just say, you know what? We're going to kick you off of our platform. You won't be able to use our self-driving car for a month, or our social network, or all of the other services that you use on our platform. Will we have this kind of private enforcement in the future? And so law and technology necessarily needs to move not just towards safe systems, but towards safe and just systems. The safe systems approach recognizes that people will fail. Right? We can expand that to say companies will fail, machines will fail, regulators will fail. And it asks, how do we design our systems to limit the opportunities for and harms from these failures? This applies to safety. This applies to equity and justice as well. Law is beginning to ask these questions, not just for automated driving, but for transportation more generally. Automated driving represents, in some ways, an opportunity to do things right that we haven't necessarily availed ourselves of in the past. And this is why I say better law is very important for the societal success of AVs. This might be the chance to do things well. Because if we don't, automated vehicles are going to happen. Companies will see to that, and they will be on the streets. The question is, will they be in the streets in a way that best serves society? So I discuss some of these concepts in this particular paper, Ethics of AI in Transport. Yeah, I know I said law and ethics are separate. I suppose appropriately for a topic on ethics lied. But you can read about it. You can read my other publications at newlypossible.org if you're interested. And I would love, in the time that we have, to ask questions, answer questions, hear what you're thinking. Thank you.